Welcome to everyone. It might be good morning or good afternoon, good evening, depending on where you are in the world, but we're very excited to have you with us here this evening. Again, my name is Christopher Ricciuti. I'm a partner in Oblon's litigation and post-grant practice group, and I focus on PTAB, district court litigation, and federal circuit appeals, dealing with mechanical, electrical, and computer software technologies. I'll pass it over to Michael, who can give you a brief introduction of himself.
Good evening for everyone here in the U.S. Thank you for staying up late, and good morning to everyone in Asia and in Europe, especially the people in Europe who have obviously gotten up very early. I'm Michael Casey. I am also a partner at the Oblon firm, and my practice areas are litigation and post-grant, as well as electrical and computer patent prosecution. We want to welcome you. We're going to split this presentation up into 6 sections, and I will discuss the first section, and then I will pass the platform back to Chris, and he'll do the second, and then we'll switch back and forth. And as Samantha said, if you have questions, please feel free to use the chat box down below, and we'll try to get to people at the appropriate pause in the presentation. So as the opening, I'm going to discuss, go ahead, Sam, next slide. I'm going to discuss some recent statistics that relate to institution decisions, claim cancellation rates, and denials over the next 5 years. Next slide. So in the upper left-hand side, you'll see a graph of institution rates by patent, and on the upper right-hand side, it's institution rates by petition. These two graphs are a little different because, as you might imagine, there are a number of patents that are challenged with more than one petition. So you'll see, for example, on the left-hand side, there were 1,022 patents for which petitions were filed in fiscal year 2017. But by comparison, when you look at the number of petitions, there were actually 1,512 petitions filed on those same 1,022 patents. So that means that there were 500 more petitions and patents, indicating that very many of the patents had 2, if not 3, challenges filed against them. The graphs show you fiscal year 2017 through 2021. The 2021 statistics are only year to date because it's not actually completed yet. And in fact, they're through April 30th of 2021. The average rate of institutions, those are petitions that were filed and for which the PTAB decided to institute a proceeding, on average have been about 69% over the last 5 years. But when that's institution rates by patent, institution rates by petition is about 62%. There was a small dip in 2020 in both institution rates by patent and by petition, but not so much that we can establish any kind of trend. We overlaid the two institution rates in the center graph so you can see they correlate, and we look like we're essentially on track for 2021 to be very similar to the 4 years preceding. Next slide. So you probably want to know how this is going to relate to your technology area. The two graphs are institution rates by technology. On the left-hand side, it's fiscal year 2020. On the right-hand side, it's year to date for fiscal year 2021. The institution rates by technology show that in the electrical computer area this year is the largest of all the areas in which petitions are filed. 62% of petitions in the electrical computer area are granted. That's 264 out of the 424. The second largest area is also at a 62% institution rate, and that's the mechanical and business method area. The smallest area in terms of petitions filed is the biopharma area. There's only been 40 petitions filed this year, but there's still a better than 50 and almost a 60% chance of institution on those petitions. The smallest institution rate is the chemical area, and there haven't been very many statistically, but 27 out of 58. This is down as you compare it to the left-hand side substantially from the year before, where there was a 59% institution rate. And the final piece of information shared between the two graphs is design patents, although the numbers there are so small, it may not be we may not be able to make real statistical conclusions on designs. But 4 out of 5 design petitions were granted. So if you were the petitioner in the design world, you're doing pretty well. Next slide. So how does this correlate to actual patent claims? For the claims for which there was an outcome in fiscal year 2020, that's October 1st through September 30th, there were nearly 28,000 patent claims in the patents that were challenged. Of those 28,000 patent claims, more than 9,000, roughly a third of the patent claims were not challenged in any of the petitions. But of the 18,000 that were challenged, the next graph, the second to right graph in the slide shows that no decision on institution was made on 1,472. So how does that happen? That happens because the parties settled prior to a decision on institution. A petitioner files a petition, the patent owner sees the petition and says, okay, I'm willing to settle, or that they have had ongoing litigation and they reach a settlement. Either way, the parties agree to a dismissal, to a termination of the proceeding is a better term. And so 1,472 of the challenged claims never actually had an institution decision at all. The number just under that is disclaimed, patent claims disclaimed. That's 225 in fiscal year 2020. And that typically happens when a patent owner wants to avoid the institution of the proceeding. And so they disclaim the patents that are being challenged. And if there are no patent claims that are left to be challenged, then of course the board is not going to institute. Of the remaining patent claims in these patents, 6,659 claims were part of petitions that were denied, but a full third of the original claims of the patents, 9,663, actually were instituted. From the instituted claims, all the way on the right, you'll see that there was no final written decision for more than 2,000 of those claims. So again, how does that happen? That happens because the parties have settled out and the patent office terminates prior to a final written decision. There are also 550 additional patent claims that were disclaimed. And probably the statistics that are most important for people listening here are that 1,852 patent claims out of the 18,000 challenged were found to be patentable, and 5,125 were found to be unpatentable. That means that 28% of challenged claims and 53% of instituted claims were found unpatentable by a preponderance of the evidence. Those numbers are very significant and shows that post-grant review of patents has been a very effective weapon for patent challengers. Next slide. So we try to give you a graph of generally what this correlates to in terms of patent size to let you see how often patents are challenged and what the results are. The graph generally shows you that there are 4 million patents in force at the moment. 400,000 were granted in fiscal year 2020. So that gives you a general scope. Now, patents challenged at the PTAB in 2020 were roughly 1,200. But the statistics that are more important is that patents receiving a final written decision at the PTAB were 413 patents. Of those 413 patents that lost one or more claims in a final written decision were 345. So and in addition, patents losing all of the claims in the patent in a final written decision were almost a quarter at 111. So on a case-by-case basis, there's an 84% chance that at least one claim of patent challenged would be canceled if the case proceeded to a final written decision. That kind of success rate is why people use post-grant review of patents as an effective tool when litigating, or as part of a litigation strategy, or when one knows that there's a particular patent that is of vital importance or that needs to be challenged. So those are the general statistics for the recent years, and I'm going to pass it over to Chris to talk about the Fintiv discretionary review.
Thank you, Michael. And Sam, if we could hop to the next slide. So as Michael mentioned, I will talk about Fintiv, and if we actually can go to slide 9. One more slide. Thank you, Sam. So, sorry, one back, apologies. There we go, slide 9. Obviously, the merits of an IPR petition are very, very important. Petitioners spend a lot of time searching and trying to find prior art, coming up with unpatentability arguments to, if you're a petitioner, you hope that they're going to succeed and you're going to render these claims unpatentable and have the patent office cancel them. However, the patent office has always had discretion to avoid institution, and that discretion has really exploded in 2020 under what we would call the Fintiv or the NHK Fintiv factors. And you have the 6 factors on the slide here, but essentially what the board is looking at is if they feel that substantial resources have been invested in the parallel district court proceeding, they may say, setting the merits of this IPR petition aside, we're not going to actually go ahead and institute and review the patent because we don't believe it would be an efficient use of our resources. So, this is a bit of a wild card for petitioners because while we have these factors here, it is very fact dependent and it's very panel dependent. And so we don't know exactly how this is going to turn out. And are going to take this type of argument whenever they believe it's appropriate, because it can be a very effective tool to avoid institution, which if you go back to the statistics that Michael was talking about, that's a patent owner's best bet to save their claims, is avoiding institution altogether. Once you get into the IPR, the statistics that don't look so good for a patent owner's perspective. Next slide, please. And so these graphs here, we've reproduced them from Unified Patents, which people on the call may be familiar with. And this just gives you an idea of how this discretionary denial practice of the PTAB has really gained popularity before the board. If you go back to year 2016, there were essentially 77 procedural denials for one reason or another. When you go to 2020, there were 228 procedural denials, which almost match the 292 denials that were based on the merits. Looking at the graph on the right, actually 167 of those 228 procedural denials in 2020 were under 314A, which by and large is probably a Fintiv analysis. If we go to the next slide. This is Unified here projecting out what may happen in 2021 if the 2020 trends hold. And they're projecting a potential 240 discretionary denials under section 314A. You see that in the left graph. And then if you go to the right, they were projecting about 172 of those could be based upon this NHK Fintiv discretionary denial regime. So a large number of petitions in 2021 will simply be denied because the board does not believe the resources and the investment in parallel proceedings really warrant the board's time to take a look. And in fact, if the 2020 trends continue throughout 2021, we could even see more procedural denials in 2021 than merit-based denials. So it's absolutely something that both petitioners and patent owners need to be very well aware of. Next slide, please. For anyone that's been following recent litigation trends in the U.S., you probably have heard of the Western District of Texas and Judge Albright becoming a very prolific patent court. Again, these numbers are from Unified Patents, and if you look at 2018, the Western District of Texas only had about 89 patent cases, and this is the year that Judge Albright was seated on the bench in Waco. It goes up to 273 in 2019, and then all the way up to 1,067 in 2020. If you look at the slide or the graph at the bottom right, just in Q1 of 2021 alone, the Western District of Texas had 200 plus patent cases, outpacing all of the other jurisdictions in the U.S. that we normally think of dealing with patent litigation. And I think the stats are right around now, about 20% of U.S. patent litigation is before Judge Albright. Why does this matter for Fintiv? Well, Judge Albright moves very fast, and a fast court is not going to be your friend if you're a petitioner and you want to try to get your case instituted and decrease the likelihood of a discretionary denial under Fintiv. There was a 2020 study of 39 institution decisions addressing Fintiv where there was a parallel district court litigation before Judge Albright, and there were 15 reported denials and 24 instituted cases. So approximately 40% of cases that were involved in this study never made it to the merits phase because of this Fintiv analysis. Next slide. So we have a number of cases here on the next few slides that I'll go through pretty quickly here just to give you a sense of what are some of the factors that the board is looking at that they find to be compelling or interesting to either deny institution under Fintiv or potentially grant an IPR even though the patent owner raised a Fintiv argument. So the first one, and these three all deal with denials under Fintiv. So a petition was filed, the patent owner submitted a preliminary response. Part of that preliminary response said, board, even if you think the merits of this case are strong, you should still deny institution under your discretion because there's an advanced proceeding somewhere else that doesn't warrant the time here. So the first one is the Stanley Black & Decker case. This one I think is interesting to note because it involved a parallel ITC case. For those that are familiar, even if you're unfamiliar with the ITC or the International Trade Commission, this is an agency that deals with stopping importation of infringing goods, and they move very, very fast. They don't stay cases in view of IPRs 99% of the time, and they will beat the PTAB to a final decision probably 90% of the time, if not more. And so very often when there's an ITC case and a patent owner raises a Fintiv argument, it's a very compelling reason for the board to potentially exercise their discretion and deny institution under Fintiv. The second one was the Kimi case from March of this year. And I think the striking thing here is that the petitioner clearly waited long to the process, and the district court case was supposed to go to trial approximately a year before the patent owner or before trial was to proceed before the district court. And if you find yourself in that sort of disparity where there's a very large gap between district court trial and when the PTAB might issue a final written decision, good, compelling facts to potentially receive a Fintiv denial. In the TCO case from February of this year, this was actually dealt with a PGR, so a post-grant review, not an IPR. And I think the interesting part about this case is the delta between the district court litigation and the final written decision for the petitioner was only about a month. But there was another parallel proceeding with a different petitioner involving the same patents. It was about 4 months ahead of the anticipated final written decision date. And because of that other trial, the board denied institution under Fintiv. So if you find yourself in a situation where you're in a multi-defendant case or a situation where the patent owner has sued defendants in different jurisdictions, you need to be mindful of what's happening in those other cases, because that could impact your own case and how the board is going to assess Fintiv. Next slide, please. So here we have cases where there was institution despite a Fintiv argument. The first one we'll talk about is the Dish Network case. And here, what I think is important is that they quickly got their IPR petition on file after infringement contentions, I believe less than 3 months after the infringement contentions, so early in the case. There was a lot left to do in the district court litigation. And one of the important things that we're seeing now, especially for petitioners, is that the PTAB seems to be recognizing that these trial dates are not set in stone, and a lot can change in between filing of the petition and the anticipated trial date. And they're viewing that in a way that is more favorable for petitioners and saying, you know, we don't really know if this case is going to go forward when the judge thinks it will. So we're not going to put too much faith in that scheduling order. And we'll see that coming up again. In Hulu, this petitioner got on file very quickly after they were served, within 4 months. If you're able to get the art and get something on file quickly, that is a very good way to lessen your chances of a Fintiv denial. And they also filed a stipulation here that they wouldn't pursue in district court any grounds using the primary references from the IPR, which mitigates to some degree the concern of duplicative efforts between the district court and the board, and the two issuing conflicting decisions. And so we'll talk about that a little bit more in a few minutes, but when a petitioner files a stipulation that essentially says, I'm going to time shift statutory estoppel, and I'll agree that if you institute, I won't raise grounds that are in the IPR or that reasonably could have been raised, the board looks at that in a very compelling way to potentially institute, notwithstanding Fintiv. Next slide. So here we have ByteDance, similar facts, and I think it's just important to kind of see these repeated, especially if you're a potential petitioner thinking about filing it. When you have a close proximity between the board's final written decision and the trial date, the Fintiv factors and the weight of Fintiv becomes less. There was also a stipulation here, again, to reduce the overlapping issues between what was going to happen in the district court and what would happen before the PTAB, so there was an institution. And HP, the second case on this slide, again, we see the board recognizing that trial dates may slip, recognizing that this petition apparently had very strong merits, and so those were compelling reasons to allow institution, notwithstanding patent owners' arguments that Fintiv should apply and institution should be denied. And the Google case, the last one on the slide, really the point that I want to make here is this is an interesting one of the first I've seen, given that PGRs are fairly rarely used, or at least AIA patents are just now starting to become the majority of patents out there that are subject to the PGR proceedings. The board noted that even though this petitioner waited approximately 9 months after being sued, those 9 months corresponded with the PGR window where they could not file an IPR. And so the board looked very favorably on that and said, in these circumstances, we're going to institute notwithstanding Fintiv. Next slide. So I think we kind of covered these practical considerations throughout the discussion, but the big thing, especially if Fintiv sticks, and it's something that we have to deal with going forward, is get the IPR on file as early as possible and as practical to lessen the likelihood of denial. And of course, this is going to be court dependent. You find yourself before Judge Albright, in Waco, Texas, the judges in the Eastern District of Texas, or before the ITC, you have a greater Fintiv risk, whereas if you're in a slower court, the Fintiv risk becomes less. Next slide. So some interesting cases here. Sand Revolution is a case where the PTAB said that they're essentially willing to reconsider their discretionary denial if circumstances have changed. Now, of course, you only have 30 days to point to change circumstances, but they will do that. And I think this is interesting because even the Fintiv case that we're talking about, and that was supposed to get the trial before the board would issue a final written decision, and therefore they didn't grant institution, that case still hasn't gone to trial. For those who are familiar with the very large jury verdicts that have come out of the VLSI, the Intel cases, the third trial there in the saga, one, the patent owner won, the second one, the defendant won, and they're set for a third trial. That got pushed back to December 2021, which is actually after the anticipated final written decision in an IPR, but that IPR was denied institution under Fintiv. So changing circumstances can happen. If you find yourself within the rehearing window, you can point that out to the board and maybe gain some traction there. The Cetera case tells us about stipulations being very important from the petitioner's perspective. Another note about Judge Albright, he's expressed an unwillingness to stay cases, so you have to consider that, and that kind of mutes the stay factor of Fintiv. And if you think you might have Fintiv problems, always consider ex parte reexamination. Next slide. And one of the things that is occurring in parallel to all this development at the PTAB is a number of parties, Apple, Cisco, Google, and Intel, they've actually sued the USPTO saying that the way these Fintiv factors were promulgated was improper. They needed to go through official notice and rulemaking rather than essentially issuing a precedential decision. And so because of that, they violate the APA, and it should be stayed. There was a hearing before Judge Davila in March of this year, and he actually suggested that Fintiv should have gone through notice and comment rulemaking. So we're monitoring that, but an injunction could issue. The new administration at the PTO may modify Fintiv, may pull back on it. So certainly a very important trend if it continues, but there are some developments and things happening that could change the landscape. And everyone, if you're interested in the PTAB and what's happening there, certainly watch out for that. And there was one question from an audience member that, is there a sense that PGR is largely avoided even when available because of the broader estoppel provision? Great question, and I think, yes, that's absolutely part of it. I'm going to turn it back over here to Michael soon. He may have additional thoughts. I think the larger estoppel is a key factor, and also that window is very small, and sometime, particularly if you haven't yet been sued, you may not want to try to figure out all of the arguments that you can bring in a PGR and get all of your ducks in a row that quickly and pull the trigger proactively, when if the PGR doesn't go your way and then you are sued, going back to the estoppel point, you could be in a bad situation. And with that, I'll send it back to Michael.
Great, thank you. No, I agree with you on the PGR question. So next slide, Sam. So Chris talked about the Fintiv discretionary denials under Section 314, which are really procedural in nature. I'm going to talk about the advanced bionics discretionary denials under 325, which are more based on the cumulativeness of prior art and the argument that the Patent Office has already considered the issues that a petitioner is attempting to present in a new petition. Next slide. So discretionary institution denials under advanced bionics are really covered by 35 U.S.C. 325D, and states that the board can deny an IPR petition if, quote, the same or substantially the same prior arguments previously were presented to the office. The advanced bionics decision lays out a two-part test, but it's really based on an earlier decision, Becton-Dickinson, that was a precedential decision made precedential by the board in March of 2018. The Becton-Dickinson decision set forth 6 different factors to look at, and advanced bionics took those 6 factors and broke them into a 2-pronged test to determine whether or not the board should use its discretion in denying institution. So the first prong of the test is really the Becton-Dickinson factors A, B, and D, and it looks at whether or not the same or substantially the same art previously was presented to the Patent Office, or whether the same or substantially the same arguments were previously presented. So you can have art that looks very similar, or you can have arguments that look very similar. Either one will trigger prong 1 to be met, and then the second prong is if either condition of the first part of the framework is satisfied, has the petitioner demonstrated that the office erred in a manner material to the patentability of the challenged claims. And those are based on the Becton-Dickinson factors C, E, and F. This is the petitioner's burden to overcome. The petitioner has to show that if it's using art that can arguably be found to be the same or substantially the same, or it's using arguments that were previously presented, that the Patent Office somehow made a mistake. So this isn't an issue that the PTAB wants to constantly relitigate. The panel in advanced bionics held that it cannot be said that the office erred in a manner material to patentability just because reasonable minds can disagree. So what the Patent Office was saying there is, if it's a close call, we're not going to second guess earlier panels, and we're not going to second guess earlier examiners. If an earlier examiner already considered essentially the same arguments, as Chris was saying earlier under the other discretionary denials, we don't want to waste the PTAB's resources in deciding the case. The PTAB has limited resources, and IPRs and PGRs are time consuming to decide. So they're trying to streamline the process by making sure that they're not getting bogged down in arguments that have already been presented. Next slide. So there are a couple exemplary 325D decisions that I'd like to talk about. One goes in favor of denial and one goes in favor of institution, and we're going to try to compare and contrast them a little bit. The first one is the GlaxoSmithKline decision from July of 2020. In that, institution was denied in view of the office's prior consideration of 3 references. And most importantly, I think in the denial was that the first reference actually was applied and specifically discussed during prosecution. This makes it very, very difficult for a petitioner to show that there is not some sort of relitigation of an issue that the Patent Office has already decided. The second reference was listed by the patent owner in an IDS and later considered by the examiner in a related application, again showing that these were the kinds of issues that the Patent Office had already considered when it made its decision to issue the patent. The third, which is probably harder to show, is that the third reference was determined to be cumulative of the first reference and others considered by the examiner. anytime you're using something that's simply cumulative, I think it doesn't really add a whole lot. So really the third reference falls into being similar to the first, but rather than being the same prior art, it is similar arguments that were made. And basically the petitioner's main problem was that it did not adequately explain how the examiner erred in its weighting of secondary considerations evidence. So when they looked at this other prior art during examination, the patent examiner was fully aware of it. It looked at other secondary considerations and said the secondary considerations outweigh the teachings of the primary reference. And as a result, the patent was granted. And the board says, well, we're not going to second guess that. By contrast, Otacon Medical is a case where an IPR was instituted despite the 325 arguments that were made by the patentee. So in this case, the petition is filed. The patent owner tries to avoid institution by arguing that this is like many other cases that where 325 controls and the patent office should use its discretion in denying. But the main difference was that the IPR art provided a different structure from that relied on during prosecution, which also had advantages tied to the petitioner's motivation to combine arguments. So petitioners generally should attempt to show different structure and or motivation in order to increase the likelihood of institution. That's the real takeaway from 325D. You want to make sure that you can avoid the first prong, and if you even if you find that the patent office is going to say there is the first prong is met, you want to show that the patent office erred in some sort of analysis that would have materially changed the patentability of the claims. So I'm going to turn it back to Chris to talk about motions to amend.
Thank you, Michael. So yeah, we'll talk about motions to amend next. And for those that may not be aware, I believe it was towards the end of 2018, the Patent Office instituted a pilot program where they changed the mechanisms of motion to amend practice, hopefully to allow it to be easier to try to amend a claim in a post-grant proceeding. And we'll just take a look at some stats, see how that has changed the landscape. So we could go to the next slide. This is looking, these numbers are from the U.S.PTO, excuse me. And if you look between October 1st, 2012 and March 31st of 2020, how often are motions to amend filed? And the answer there is really not that often. You'll see that in 80% of the cases, there is no motion to amend. Why is that? There's probably a variety of reasons, the biggest being the fact that if you amend your claim and you have a co-pending litigation, there might be what's called intervening rights, which could preclude you from any past damages and potentially even forward-looking damages. Excuse me. And so because of that, patent owners typically do not want to try to amend their claim. So that's why we kind of see these numbers. You go ahead to the next slide. So now we'll look at before the pilot program, how successful were the people who did try to move to amend. And unfortunately, the answer for patent owners who wanted to amend in an IPR proceeding, for example, is that they were not very successful. About 13 to 14% of cases, the patent owner was actually able to get an amended claim out of the IPR process, for example. Next slide. And why is that? And that's what we see here on slide 25. 8% of the time, it was some sort of procedural error, so that's a small percentage, but 92% of the time, there was a statutory reason that the PTAB felt that these amended claims should not actually be issued, and they're potentially not patentable. The office breaks that down and shows us that 47% of the time, which is the orange slice of the pie there, that the patent owner simply didn't establish that the proposed amended claims were patentable over an anticipatory reference or over an obviousness combination. 34% of the time, and really the rest of the pie, if you look at the 34% and then 7% in section 112, is that, so we're talking 40% of the time that the patent owner could not show that there was written description support for the challenge claims or the amended claims, excuse me. Maybe they were alleged to be indefinite, and the board agreed with that. So it's important to keep in mind that the PTAB judges, not only are they very technically competent, they understand how to do these contested proceedings, they're also very good patent practitioners. And if you give them a claim amendment that doesn't have 112 support, they're going to call you on it, and you're not going to get your claim out of the proceeding. Section 316 might be a shortcoming of the movement or the patent owner to meet all of the requirements that you have to meet when you file a motion to amend. And actually, sometimes 6% of the time, 101 came up. And this is actually very interesting because, as you may be aware, Section 101 is not a valid ground for a challenge at an IPR unless you're going to go ahead as a patent owner and file a motion to amend. Then the board actually can consider 101 issues with respect to the proposed amended claims. Next slide. And so this is the last slide on this issue. It gives you some comparison and contrasting numbers about the pilot program and what's happened. There's been 128 motions to amend under this pilot program. What the pilot program allows is for the patent owner to get preliminary guidance on the motion, essentially get a preview of what the board thinks about the proposed amended claims. 81% of patent owners have taken advantage of that. Of those 81%, 80% have actually tweaked their claim in some way or their motion in some way in response to what the board had to say. And so because of that, we are actually seeing more success, 23% as opposed to that 13 or 14% number that we talked about earlier. And so almost a doubling. So that's great. It's very encouraging for patent owners to see that increase, to see that this pilot program is helping them, that it's having success, but also bear in mind, even with this pilot program, it's not going to change the fact that in the vast majority of cases, patent owners are just not going to be interested in amending their claims in an IP. And with that, back to you, Michael.
Thank you. Next slide. So the next area of discussion is the standing to appeal. It may seem strange to practitioners outside the United States that a patent can be challenged at the patent office by a petitioner, and the petitioner might not actually be able to go forward with an appeal if the petitioner is unhappy with the decision with the final written decision. Next slide. So an IPR petitioner standing to appeal an adverse final written decision is based in the U.S. Constitution. So although 35 U.S.C. 315A allows any person other than the patent owner to file the IPR request, the Constitution requires that there be what we call constitutional standing in order to appeal an adverse decision to the Federal Circuit. So in order to show that one has constitutional standing, there has to be an injury in fact that's fairly traceable to the appellee's conduct and likely to be redressed by a favorable judicial decision. So the second two factors, the fairly traceable to the appellee's conduct and likely to be redressed by a favorable judicial action, are almost always met. I can't really imagine a case where you wouldn't be able to show that you can't meet those. It's based on a patent that the person is challenging, and it's can be redressed by the court by potentially invalidating the claims. So the question really turns on injury in fact. So one of the main ways to show this would be a specific threat of litigation. that would definitely be evidence of a potential injury in fact. So what happens if there is no specific threat of infringement? What is sufficient short of an express threat? Next slide, please. Interestingly, GE is going to be in both of these cases, and both of these cases deal with gear fanned engine designs. In deciding the standing issue, the Federal Circuit assesses whether there was current activity or concrete plans for future activity that creates a substantial risk of future infringement, or that would likely cause the patentee to assert a claim of infringement. So in the first case, the GE versus United Tech, GE argued that the patent in question impeded its ability to use gear fanned engine designs when bidding, but GE did not put in substantial other evidence, such as that they were losing bids because GE had to offer technology that wasn't implicated by the patent, or that GE offered alternative technology because of the patent, or that the amount of time or GE also didn't provide the amount of time and money invested in designs that could implicate the patent, but that GE didn't offer for fear of suit in light of the patent. Next slide. Having learned from its loss in the United Tech case, GE in the GE versus Raytheon case in the Federal Circuit in 2020 successfully was able to show that it did have standing. GE argued that it spent $10 to $12 million in 2019 developing a geared turbofan design. It also argued that the design is technically preferred for the next generation of engines in the market. It also offered that it had offered the design in response to an Airbus request for information. The court held that activities that will likely but might not occur in the future can be sufficient to confer standing. And in fact, the court went on to say that GE's specific investment in continued development of a geared turbofan engine design, its avowed preference to offer this design for sale, and its informal offer of this engine to Airbus in an ongoing bidding process together establish that GE will likely engage in the sale of this geared turbofan engine design to customers. So it was able to show that activities will likely but might not occur in the future, and that therefore provided them with standing to appeal. One of the problems, though, is let's assume that next slide, please. Let's assume that a petitioner is unhappy with the final written decision. How does it proceed? What are the practical considerations? Well, first of all, there's a pre-filing consideration, which is for IPRs that are filed before suit or being threatened with suit. The potential petitioner really should consider the risk of not being able to appeal an adverse decision. Or is the client going to be upset that we've gone down the road of filing the petition, had the trial, we get an adverse decision, and then there's no recourse left? But let's assume that you did actually get an adverse final decision, and the petitioner is trying to decide what to do. Well, one of the things that the petitioner needs to do is assess whether or not during the appeal process, they're going to have to say more than they would be comfortable saying. If you remember in the last slide, we talked about all the factors that GE laid out, including how much it spent, that the design was technologically preferred, and that the design was already offered. Those may be factors that a petitioner is not really willing to put on the record because they may be used against it in parallel proceedings. So even if a petitioner loses, the petitioner may ultimately decide that it's not willing to put up the information on the record that would allow it to win. So that is another one of the practical considerations. In general, as a practitioner, to prevent dismissal, you should try to align your facts as closely as you can with cases where standing's been found. The investment amounts are very very convincing, as are the threats if they existed. So practitioners should try to make sure that they assess the best way to prove that they have standing, because the Federal Circuit is going to hold you to the constitutional standard as opposed to just being the appellant from a PTAB proceeding. Chris?
Thank you, Michael. And yeah, I think one final point on the standing is that, if you look at the stats of what the Federal Circuit is doing with these IPR appeals coming from the PTAB, it's somewhere around 70 to 80% of the time the PTAB is getting affirmed. So if you are a losing petitioner and you haven't yet been sued, you haven't been threatened with suit, and there's an approximate 70% chance that that bad decision you received is going to get affirmed, you really want to think about all the things that Michael just went through and whether it's worth creating that record in view of the facts that you have, and how strong or how good or bad do you think that final written decision is. There was one question on the motion to amend topic that I didn't see earlier, which was, in a motion to amend, can the petitioner raise new 102 or 103 arguments versus the petition to rebut patentability of the amended claims? And that is exactly right. If you do find yourself in an IPR proceeding where you have we'll call it the original petition and then a motion to amend, they kind of proceed on two parallel tracks. You'll get briefing schedules for both of those. And as part of that, when the patent owner moves to amend, you as the petitioner can put forward new grounds on patentability. If you need to do new prior art searching, you can go ahead and do that. And so finally, the last topic of tonight, and I'll hit this quickly because I know that we are almost running out of time here, and we don't want to, everybody has a busy day to get to, is the PTAB. Are they an obviousness court? And I think a lot of people anecdotally know that, but the facts really drive it home. They are absolutely a tribunal that is kind of built in view of the technical expertise of the PTAB judges to assess obviousness, and that's what they do. Out of 12,095 IPR petitions that were filed as of May 12, 2021, 98.2% contained obviousness grounds. Only 1.8% contained anticipation only. About 36% contained a mix of the two statutory basis. And so over 60% of IPR petitions actually contain no anticipation obviousness, no anticipation arguments at all. Next slide. When you look at petitions that are instituted, these numbers basically track. About 30% of petitions that are instituted contain a mix of anticipation or obviousness grounds. About 4% contain only anticipation. And again, it's over 60% of instituted IPRs deal only with obviousness. Next slide. And this is just here on slide 35 to key us in that now we're going to take a quick look at final written decisions and what happens there. Next slide, please. You have a lot of numbers on this slide. I know it's probably a lot to look at, but in short, when we look at what works, 41.2% of total obviousness arguments were successful, in contrast to 36.5% of anticipation arguments. So even all things being equal, the numbers still show that there's a greater likelihood of an obviousness argument succeeding when you look at it, a one-to-one case basis. And in fact, there were only 111 cases where petitioners succeeded based on anticipation only. In cases where all claims were found unpatentable, 22% were based on anticipation and 78% were based on obviousness. And if we flip that, even when all claims were found unpatentable, if we look at the arguments that didn't work, 8% of the time it was an obviousness argument that failed, 16% of the time it was an anticipation argument that failed. So I know a lot of practitioners, especially some of our European colleagues, where obviousness or inventive step is just not as common, and piecing together 2, 3, or 4 references just doesn't happen. It is certainly a different story before the PTAB. It's what they are equipped to do. It is what they do, in fact, do, I think, day in and day out. And so while we all love to have a very solid anticipation argument, if it's not there and you have a very strong obviousness argument, I think as a petitioner, you can feel comfortable that that type of argument is something that the board sees all the time and is not going to think twice about it, because it is obviousness and not anticipation. And so with that, if there are no other questions, and it doesn't look like they are, I believe somebody had asked that if they could have a copy of the slide deck, and I do believe that Samantha will be providing copies for everyone. We really appreciate your time, whether it was the morning for you, early morning, in the afternoon, or potentially late at night. It was great meeting you virtually here over this platform. Thanks Samantha and IAM for putting this event together. We hope that you enjoyed the talk. I know Michael and myself enjoyed being able to give it to you, and we wish you a great rest of your day.
Thank you very much.